using the testimony of former employees in your nursing home cases. Stick around. Hey out there, everybody. Welcome back to the Nursing Home Abuse Podcast. My name is Rob. I will be your host for this episode. Today, we're talking all about gathering the statements and testimony of former employees and what we do with that and why we are seeking that testimony. But we're not doing it alone. We have the fantastic trial attorney, Tom Pleasant, out of North Carolina to talk to us today about that. But before we get into it, let us get into the nursing home regulation question of the week. This week, the difficulty level, I'm going to say, is medium hard. So if you get this right, give yourself a pat on the back and let's say 72 points. Under 42 U.S.C. 483.35, unless a waiver is granted, the facility must designate a registered nurse as director of nursing, A, on a full-time basis, B, on a part-time basis, or C, on a per-quarter basis. And the answer to that is A, a full-time basis. So unless there's some type of application for waiver because of the size of the facility, the director of nursing must be available on a full-time basis. And now it's time for everybody's favorite, the ChatGPT generated nursing home regulation joke of the week. Gentle reminder, everybody, as we say every week, that this is AI's attempt to combine humor with United States code. So set your expectations to more than likely devastated.
The ChatGPT generated nursing home regulation joke of the week.
Skynet.
Did you hear about the nursing home trying to add waiving your rights to the activity schedule? Turns out Regulation 42, USC 483.15a2, said it was the one game where you can't pass go, can't collect $200, and definitely can't sign away your rights. Talk about a monopoly on fun.
And there you are, folks. Further proof that the singularity is at least a little while away. All right, now it is time to get into the meat and potatoes of the episode. Got a great episode today. Have a terrific conversation with our guest, Tom Pleasant. What a great guy. Tom Pleasant is a trial attorney. He's licensed in North Carolina, Georgia, Kentucky, and Tennessee. Brings nearly 30 years of legal expertise to his practice, specializing in catastrophic injury, accident, and wrongful death cases, particularly in nursing home and long-term care settings for over 16 years. Thomas has an impressive track record. He holds a Martindale-Hubbell AV preeminent rating and has been elected to Super Lawyers, showcasing his high peer recognition and professional achievement. And if that's not enough, when the guests will send me their bios, Tom has actually included the symbols for the registered trademark of Martindale-Hubbell and Super Lawyers, as well as the TM for trademark for AV preeminent. So his attention to detail is unwavering. He's a graduate of Jerry Spence's Trial Lawyers College, and he has successfully tried numerous jury trials, including medical malpractice cases and nursing home cases. And we're so happy to have him. Tom, welcome to the show.
Hey, Rob, thanks for having me.
All right.
I appreciate it.
Yeah. So I think that a big differentiator in value of a case is, on one side, you have cases in which you're relying on the chart, what your clients are saying, perhaps what you found in open records request. And then you have, on the other end, you've got a case where you have all that, but you have actual people that were at the facility, former employees that are willing to testify. And I feel like there's a big difference in value between those two. So I'm glad to have you on to talk about why there is a difference. So the first thing is what would make you seek out the testimony of former employees in a particular nursing home case?
Well, I agree with you, Rob. I think it does increase the value of a case. It may depend on the case whether the cost and time is justified. But I've been doing long-term care cases almost exclusively for over 16 years. And I find that almost all cases are driven by understaffing, and or some form of lack of resources. And I think it leads into a theme for your case that is bigger than just your resident or your victim. It makes it about what's going on with this corporation, why are they not funding the facility like they need to, and what is the effect on the residents generally, and in addition, your own resident or victim in your case. So generally, my approach with former employees is to get to the understaffing and the general conditions of the facility, to try to get evidence of that to use at trial. And as we all know, the defense is going to evaluate the case and put a value on it based on what they think is going to happen at trial, as do we. So that's my approach, and I have a formula that I think works to kind of set this out. It's a broad formula, and it can take different forms in different cases, but generally you have former employees who talk about the lack of staff and or resources, and that they've complained to management in some form or fashion. Management was aware, and basically there was no response. And typically you find that, I think that's because the people who hold the purse strings are just not willing to spend the money, despite in many cases the facility having more than adequate resources to fund extra staff and or resources for whatever purpose.
So it's almost as though, like, obviously, if you can find a former employee that remembers your specific client or knows maybe what happened, if it's a fall case or whatever, that's great. But in reality, you're looking for a broader strategy to link what they're going to say to a narrative that they didn't have enough people, didn't have enough stuff. So what's kind of like, what are you looking for them to say? Like what can they say that feeds that narrative?
Well, I think this whole concept of former employees is on a sliding scale, so to speak. I mean, you could find employees who may not have had anything to do with your resident who could talk about the conditions in the facility. I think that falls on the end of the scale of more difficulties with getting that into evidence. Mm-hmm. I do frequently run across employees who did remember my victim. In fact, I just recently did a recorded statement with a witness who actually very much remembered this resident. And so I think it just kind of depends on what each individual former employee has to say and what they can talk about.
Right.
And that can create, some difficulties. I recently got a recorded statement, and this is the one I'm talking about. This lady who remembered my resident, but my resident was actually moved from her unit to a different unit about a year before kind of everything really started falling apart for my client, my victim, my resident, in terms of wound development. And she just could not really and would not really speak about understaffing across the whole facility. And so she probably had some good things to say that will help me lay the foundation for doing some other discovery. So I don't think it was totally wasted, but that's another option. If you can get a statement from a former employee and they're talking about these issues, I think it can help educate a judge as to why you may need more detailed understaffing evidence, even if it wasn't particular to your resident or your resident's unit. But so, I think there's a lot of variations on how you get this evidence in. In North Carolina, for example, we do have some decent case law on, what I'll call general conditions of the facility. And I think in other states, you have that in terms of, can some former CNA come in and talk about understaffing in a facility when it doesn't have anything to do with your resident? So is the former employee, can she testify, he or she testify about, what were the conditions in the building? Can they narrow it down to what were the conditions on the unit your resident was in? And then, I think the tightest and best scenario is if you have a former employee who can talk about your resident through recollection, or at a minimum, if we know that resident took, or that former employee took care of your resident through the ADL sheets, or, through the nursing home chart. And even if they don't remember the resident specifically, I still think you've got a really good argument to get that in, to get that into evidence. So as far as the evidence rules and those sorts of things, um, most defense lawyers are going to try to challenge the stuff coming in. I've had different arguments made. I've had the argument that a CNA cannot talk about understaffing unless that CNA is actually an expert witness and designated as an expert witness in the case. Again, in North Carolina particularly, we have some pretty good law, on this, and specifically Rule 701 and and probably most evidence codes. I mean, that's North Carolina's rule. Is deals with lay opinions. And so if you read that rule, I think there's a very strong argument that you can get this stuff in, even though it's not expert testimony, but it may be somebody who has particular training and experience, like a nurse, who, although they're not giving expert testimony, they can testify about their experience. There's a case in North Carolina that talks about this with a nurse who testifies under Rule 701 as to the effect of a medication on somebody. So, and I think it's really hard. The tighter you get on that sliding scale, I think it's hard for a judge to decide that the evidence is not relevant, just basic relevant evidence on explaining why the injury happened. And if you have a former employee who is basically saying, I couldn't do my job because I couldn't get around. So if it's a pressure ulcer case and they're saying, I couldn't turn and reposition my residents every 2 hours or as needed, and they took care of your resident and your resident had a pressure ulcer, that's a pretty tight connection. And I think a judge has a hard time legitimately keeping that out of evidence.
Stepping back logistically, how are you finding the former employees? Like, what's the process?
Well, there's different ways to do it. I mean, almost exclusively, it's going to come from medical records. My preference is to do this early before a lawsuit is filed. And generally in nursing home charts, for example, if it's a skilled nursing facility, you're going to have very detailed what we call ADL sheets that are the activities of daily living. And those are the primary CNA or nurse aid. That's the primary CNA or nurse aid documentation. And in most cases, those sheets will have the full names of the CNAs or aides at the end and a key. Every now and then we run across situations where they don't produce those as part of the pre-suit production of the medical records, and that creates a real problem. But typically, I like to go in and just look at what we've got and try to narrow it down to the time frame. And obviously, it's for my resident or my victim, and just use those names. And then I subscribe to a public records service, and we find these people, or we get an investigator involved as another reason document request to ask for the information about employees at the facility. Typically, they don't like to produce that. You may have to fight for it. Sometimes we get it, sometimes we don't. But like I said, most of the time I'm trying to do this ahead of doing any discovery or even filing a lawsuit. And one of the reasons for that also is that I've found over the years that I can't say all defense lawyers will do this, but once a lawsuit's filed, and if they get wind of you, or maybe even before you start doing it, but particularly if they get wind that you've got an investigator out in the field, or you're calling these people, and word does get around, because some people will call and talk to other current employees of the facility. A lot of these folks know each other and continue to have relationships. The defense lawyers can get pretty aggressive in writing letters and sort of, walking the line of kind of intimidating these folks. They can do that a number of ways, I think, without necessarily crossing the line. But, they talk about HIPAA, and they sort of, make these low-level employees feel like, they just scare them. They may talk about, where you're going to have to, be subpoenaed to court. You're going to have to testify in a deposition. The lawyer's going to grill you. There's a number of ways I think they do that without actually crossing some, ethics rule, bright line. But, getting the list is not that difficult, especially if you've got a good ADL sheet. So once we do that, Then we decide, how are we going to approach this? Because I don't think there's one right way to do it. You can do it with an investigator. I've had success just calling these people up. It takes a lot of time. You can have staff do it, which I think is better. I think people are very intimidated if a lawyer cold calls and starts trying to talk to this person about some lawsuit. I think it's likely to backfire. So in the past, I've had staff do it and just gauge cooperation. And if somebody seems willing to cooperate and talk, well, there's a couple different things you can do. You can decide to go ahead and take a deposition, or you can get on the phone and do a recorded statement as a lawyer and just really do almost like a little mini direct exam kind of thing and have your outline ready and all the key things in the case that you want to talk about. And then at a minimum, if you end up getting somebody who's just not going to cooperate later on, and it happens all the time, even I've had it happen even after getting recorded statements from very cooperative witnesses. Even after you get that recorded statement, you may get somebody ghosting you, and you may decide that in the best interest of your clients, you just still need to go ahead and take that person's deposition. And if you have to subpoena them, just do it, just to get the evidence. I think some lawyers disagree with that approach because they feel like if somebody's not cooperating, you're just going to have problems. But I think if you've done the recorded statement in enough detail, it's really hard for them to back out of that. And I've kind of waffled on that over the years. I mean, you kind of feel bad about doing that, I guess, and subjecting people to the process if they don't really want to help. But by the same token, I feel like our job is to prosecute the case and to develop the evidence. And if we know a witness has got information that helps our client, I think we just have to do it. And that's kind of been my approach, is to just take that position. I don't threaten these people. But if they won't cooperate, I feel like, I've got to go ahead and go the subpoena route. And, one of the things that can happen too is if you use investigators, typically they're not going to know. I mean, I feed them a lot of information about the case, but they are not going to go out and do an examination. Their job is more to get a generalized statement or a general feel for what the witness knows, the level of cooperativeness, and that sort of thing, and maybe to get a very cursory kind of statement. And in my experience, if you don't follow up on that and either get a recorded statement or go ahead and get a deposition, there is a good chance. I've had it happen many times over the years where when that CNA or that former employee is sitting in a deposition, that the defense lawyer has probably ended up noticing up. They will also scare the employee. They will do things to make the employee, basically feel like they can't stick to what they said. And when you just have a bare bones statement that an investigator has done, there's not enough. You haven't locked down the testimony sufficiently, in my opinion, to avoid some of the problems that you have when that happens. I had that happen a lot early on when I first started doing this kind of work. And so that's why I've started trying to aggressively just, for lack of a better term, sort of chase after these people and try to get them on the phone. And I usually ask, in North Carolina, it's perfectly permissible to record these people without their permission if you're a party to the conversation. I tend to ask. I think it just looks better. And I don't want the defense lawyer to make it look like I'm doing something sleazy, because some people don't like that. I think they see that as, even though it may be legal, it's not really something that you should do. So I find that almost all the CNAs and aides who I've gotten statements from an investigator or who have indicated some cooperativeness will agree to be recorded. And they will also agree to do an affidavit. And that's another kind of third little follow-up that I do consider in many cases, is just going ahead and getting an affidavit. And one of the reasons for that might be, I don't know after I do a recorded statement that I necessarily want to produce that entire recorded statement. And I think, judges handle that differently. It's arguably work product. But an affidavit is a way, if you don't think you're quite prepared to just divulge the entirety of your statement, you can get an affidavit with the key stuff in it and lay it out in an organized way. to use for pre-suit negotiations.
In North Carolina, are you allowed to talk to current employees?
Yeah, I mean that's another great question because the rules about talking to these people can be kind of convoluted. In North Carolina, we have a lot of ethics opinions on all this, and some of it can be pretty confusing. And in some states that I've done cases in, Arizona is an example of this. You really almost have to just go to the judge to get an order to even talk to these people. It's very risky to do it. What I have decided to do for a number of reasons is I typically don't talk to current employees, although I think you can absolutely talk to them if they are low level and if they are not directly being sort of blamed for the conduct in the case. I would say that's a broad sort of summary kind of rule of thumb. But the reality,
yeah, I hate to interrupt, but that was kind of what I was going to ask, is because there's a certain percentage of cases in which you or your staff are the one reaching out to these or to the employees. How do you know who's still there or who's not there? How do you in your introductory call to them, is that the first question? Like, do you still work there? Like, how do you?
First question.
Yeah.
No, great question. So, the first question is, are you represented by an attorney? Because I think that's the key threshold. Because if somebody's represented, and that may kind of throw them off at first, but I think you have to ask that first and be sure, because it doesn't matter who you can contact in terms of current, former, high level, low level. If they're represented, you can't talk to them. So that's the threshold inquiry, and if you have a good investigator who's experienced with this, they will know that. But in the beginning, if you're working with a new one, you need to make sure you give them a script and that they understand what they need to do, because you're held to the conduct of your investigator. You're responsible for what that investigator does. But to answer your question, the next question would be, if you don't know already, is, are you still working at the facility? And if you have only got ADL sheets, from a case pre-suit, and you don't have a status through discovery, then you have to ask that. And my approach, in conjunction with the ethics side of it, there's a practical side of it, which is basically, I think you can expect most current employees to not be helpful in your case. And so, and if you've got a good long list of aides or CNAs, your best efforts are focused on former low level employees. That also relates to what kind of former employees are you going to talk to? You're going to try to talk to floor nurses. Technically, under the rules in North Carolina, you can talk to a floor nurse. You probably shouldn't talk to the director of nurses. You probably shouldn't talk to a charge nurse, but it's a little gray. But I think in terms of results, what I have found over the years, and what the primary investigator I've used over the years will say, is it's generally just not effective, and the focus needs to be on the CNAs, and certainly just on former CNAs. So that's always been my approach, and it's been pretty successful. It's pretty rare that he goes out and doesn't find a couple of people on every case.
That's an interesting perspective, because it seems to me what you're saying is that irrespective of what the law might be in terms of contacting former employees, being high level or low level, you're still only going to reach out to the CNAs because they have less skin in the game with their license. The CNA is more likely to tell the truth. That kind of thing. It's not necessarily because that you're okay from an ethics standpoint. Like you want the CNAs regardless.
Yeah, exactly. In other words, yes, there are considerations other than, can we contact this particular employee? It's also, where are the resources best allocated? Because it's expensive, and if you're going to get an investigator out there, usually we have a list that's long enough that the investigator is going to fill up a week, just trying to get the CNAs to talk. And then the other thing I've also found, because I've had situations where LPNs who are floor nurses have talked to the investigator and been very cooperative, and then they get cold feet. And I think on the whole, the more educated they are, the more likely they are to go home and talk to their spouse, the more likely they are, and to be talked out of talking to the lawyer, the more likely they are to go out and talk to a lawyer. I've had that happen not too long ago on a case. I had somebody set up, I was going to go meet with them, and they basically texted me back and said, I'm just not going to do this.
Right.
Now that's a person who may cooperate. You know, if I called them up and said, hey, I've got to take your deposition, I may be able to get her to talk to me a little bit. And maybe I can just gauge that she's going to be cooperative and tell the truth in the deposition. There's a chance I may notice that deposition up. In this particular case, this nurse had actually texted photos of a wound to my resident's daughter, basically, and called my resident's daughter and said, you know, this shouldn't have happened. I wanted you to know about this, blah, blah. So that's a person who, you know, in a deposition or trial setting may actually tell the truth, you know, and feel like, you know, they've really got to tell the truth. But I've had nurses come in depositions also who you just know they're lying because they're
Right.
just scared and they just don't want to be involved. You know, and CNAs are like that a lot of times too. The lower level employees, you know, these people are, you know, a lot of times they're just scraping by. They don't need to miss work. They're just scared. You know, and they just don't want to have anything to do with it. You know, so that's the big challenge. You know, it's really hard to get people to do the right thing.
What so you have the chart pre-suit, you scrape it for all the CNAs, you have your staff, you use whatever database you use to get the phone numbers, you start calling. When is it that you decide that you would rather have a PI involved in the process? Like what is your decision tree for, like, okay, this might be too much for me, or what's involved in getting the PI?
Well, that's really a threshold question. You know, I think and I don't have an answer for that. I think, you know, to some extent, I think it depends on who your staff is and how much time everybody has to do the work.
Sure.
I've had success having staff call people up and, you know, getting me in touch with them and setting up, you know, a recorded statement. I didn't mention this earlier, but one thing I've also done in the past is basically hire a court reporter and go sit down with the court reporter and have this person give me a statement under oath. You know, which is something else you can do. It's not a full deposition, but that can be effective. I haven't done that in a while, but you know,
That's a very cooperative person.
Yeah, I know. Yeah. So, you know, frankly, I haven't really I haven't used the approach of calling, you know, having staff call or calling myself up front in a long time. My default, you know, for some years has been mostly to just send an investigator out.
I see.
I think the advantage is it's much easier for people to dodge a person who's coming and knocking on the door versus, you know, somebody who's just trying to call up and, like, I don't know you and you're just calling me, and it's easy for me to block you or ghost you or whatever. You know, the downside to the investigator is it's a lot more expensive.
Yeah.
But you know, I think I kind of come down on using the investigator just because the investigator can go out for a week or whatever and sit there and try to figure out people's work patterns. They can also, well, you could do this on the phone too, but they often, when they talk to people and establish rapport with them, if you've got a good investigator, they will also often open up and give the investigator other names just in the course of, you know, chit-chatting about the facility and the case and things like that. And I've had that happen. So the cost is higher, but, you know, by my calculus, I certainly cannot pin a particular value increase to a case on having former employees. But I believe that the value of the case is increased by far more than the cost of the investigator if you can get good statements. You know, but it is a lot of work to follow up and get people to communicate with you, and then, you know, to continue to stay in touch with them and just sort of keep them on your radar, and then to take it to the next step and get the recorded statement. You know, I find it to be pretty frustrating. I mean,
No,
you've
it's a
spent all this,
challenge. I know that
yeah,
in my most recent case that I've used a private investigator, and thank you for recommending that private investigator. He got, like I think he had maybe 40 names to work with, and he got 8 statements. But out of the 8 statements, it's like half of them have ghosted me. 2 of them are on the fence of whether they want to testify, and then 1 is like, I don't know, hates my guts, I guess. I don't know, but I've got the statements. But I think you're right. I think it requires a lot of massaging, and I'm probably not massaging them in a good way. And I wasn't present when the written statements were generated, because my guy went out, got them to sign written statements, but I wasn't present. So
yeah,
anyway,
and
it
that's
can be
typically
challenging.
what I do as well. I think it's much less likely actually for one of these former employees to be cooperative if the lawyer shows up.
Mhm.
Um, I've heard, I haven't done this myself. Well, actually, I did do this one time, and I like the approach if you can do it. But if you're in the area, I mean, I know like my practice is pretty spread out, but I did have a case that was close by to where I live, and the investigator got an employee and basically talked to the employee, and then set up another meeting for me and the investigator to sit and talk.
Oh, wow.
And after that, I was able to do a really extensive affidavit with this particular former employee, and I think that works really well. But your point is exactly the way this goes down. It can be really challenging, even after they give a statement, to really do what needs to be done, and that leads to kind of the evolution of my philosophy, which is at some point, if I can't resolve this case, there's going to be a deposition probably, and I'm just going to probably subpoena these people
Hmm.
and use their statement. It's a judgment call because,
Yeah,
again, if you just have a scant, bare bones statement going into a deposition, you're not quite sure what you're going to get.
sure.
Um, but it is a challenging part of the practice to find these people and to get them on board for sure.
Agreed. Well, Tom, I really appreciate you coming on your show and sharing your knowledge. I know I'm very thankful because you recommended a great PI for me. It's helped me very much in some cases. So I just wanted to have you on and talk about that, and I really appreciate it.
Yeah, glad to help. All right, take care, Rob.
All right. Well, I hope that you found this episode educational and perhaps a tiny bit entertaining. If you have a suggestion for a topic that you would like for me to talk about, please let me know. If you have a suggestion for a guest that you would like for me to talk to, please let me know that as well. New episodes of the Nursing Home Abuse Podcast come out every single Monday on whichever platform that you get your podcast from, but you can also watch this podcast. You can actually see us talking to the guests. You can do that on YouTube or at our website, which is nursinghomeabusepodcast.com. And with that, folks, we'll see you next time. Thanks for tuning in to the Nursing Home Abuse Podcast. Nothing said on this podcast, either by the host or the guest, should be construed as legal or medical advice, nor is intended to create an attorney-client relationship between the host or their guest and the listener. New episodes for now are available every other Monday on Spotify, Apple Podcasts, or on your favorite podcast app, as well as on YouTube and our website, nursinghomeabusepodcast.com. Again, that's nursinghomeabusepodcast.com. See you next time.